Now, well, friends, though we all know, I'm trying to just rushing fast for a recapitulation. All of us, I hope, must have gone through the scheme so far. Now, the amount of tax payable will is the table is given, and I would not say touch upon this. You may refer it to this, but the date only changes that when the earlier there were two categories, that is 31st March, and then further if you fail, then with 10% additional, you could have made payment by 30th June. Now, with the taxation laws amendment, it has been extended to 30th June. And after 1st of July onward, the next date, that is yet to be notified. Presently, we have only one category of the amount of tax payable. Together with Rule 11 may be referred, which also gives the idea how to compute the tax payable. Now, the process, I would be touching, touching these procedural aspect first, and then we'll go to the controversies. The first step is that the declarant has to file a Form 1 under Section 4.1 along with Form number 2, which is an undertaking. And for waiving his right, undertaking means that he is agreeable to waive his all right and remedies available in the law once he has opted for the scheme. Then within a period of 15 days from the date of the receipt of the declaration, the designated authority shall issue a Form 3 that will be a certificate sort certifying the amount which is to be payable by the declarant as a full and final settlement under Section 5. Then within next 15 days from the date of the receipt of the said certificate by the designated authority, the declarant is required to make the payment of the amount determined, which is full and final, and that is conclusive even, cannot be challenged. I'll deal with that aspect later. And if he fails, then the consequence is that under Section 4, subsection 6, it will be deemed that no declaration having been filed. And then lastly, this then pursuant to the making of the payment, the declarant is required to file Form 4 and will intimate the payment along with the proof of withdrawal of appeal that it has been withdrawn before the Honorable ITAT and before the Honorable High Court. So far as withdrawal relate to the appeal of before the Honorable ITAT is concerned, once declaration is filed and a certificate under 5.1, that determination of tax is issued, then that will automatically lead to a withdrawal appeal before the Honorable ITAT. But so far as Honorable withdrawal appeal before Honorable High Court is concerned, then we will have to move an application before the Honorable Court, and copy thereof has to be then given to the designated authority. Now, this brings us to the last and concluding step, that after furnishing of Form 4, the designated authority is then required to pass an order in Form 5 for full and final settlement. Yes, I do. Further, the department is barred from instituting any. This is the immunity part. The department is barred. Department, the designated authority is barred to proceed for any prosecution, to impose any penalty or levy any interest. And the certificate under 5.1 shall be conclusive so as to the matters stated therein. And the further consequence will be that once you have settled, that does not mean an admission on your part. That is very important to understand, that by opting for VSV in a particular appeal, that does not mean an admission or acquiescence on your part. The other side cannot be permitted to say that once you have agreed and went into settlement, it means you have agreed to. You may remember a similar situation arises in the law tax effect matters when the department has to withdraw the appeal because of these circulars. The provision 268 itself provides a situation that it will not be treated to be a concession, admission, acquiescence on the part of the department. Next screen. Now, well, friends, with this, let me discuss with some of the issues, the gray areas which are arising. I tried to prepare some of the issues. Now, before I say that these are the issues, what I mean is that firstly, there are certain points which I wanted to bring to your notice, though truly speaking, they may not be in the nature of the dispute. And secondly, they are the issues which initially cropped up in my mind, say like the pendency of the appeal, I'll discuss it. but then later it was favorably decided by the CBDT, and for your knowledge, I would be covering those aspects also. And thirdly, the issues which are still there, gray areas which they need to be addressed adequately by the CBDT so as to avoid any further chance, because the theme of the scheme is Vivad Se Vishwas. So let there be a complete clarity, and let there be no further chance of there being Vivad even in the very understanding, interpretation and implementation of the scheme. So there may be many more issues would be covering up. Now, the CBDT, of course, came up with a circular in March consisting of 55 questions, yet it was not sufficient to cover up, and we were eagerly awaiting of the further clarifications. And when on 20th day before yesterday, when the next circular number 9 2020 came, but it was nothing but a more or less a reproduction of those earlier 55 questions only,